Hello CLAT aspirants, I hope you're all doing well. This is your mentor Riddhi, and in today's video in our law library section, we'll be talking about the Romesh Thapar case. Now before even getting into this, what is this idea, or have you ever heard something like this, that the media professionals or freedom to press is also a part of freedom to speech and expression? Yes, this is what we'll be discussing in our today's case. So let's get into it. So the image that you can see on my screen, this is with regards to our Romesh Thapar case. And what are we discussing? Now the most important thing here is the different name for this case is also the crossroads case. So in case if you're ever asked about the crossroads case, it is equivalent to your Romesh Thapar versus State of Madras. Now this year we celebrate the 75th anniversary of this case, as well as what was this case with regards to. Now this was talking about upholding the freedom of speech and expression for all the citizens, and this also includes the press. So let's try to understand the facts of this case. Now what are the facts of this case? Basically, the petitioner in this case was Romesh Thapar and the respondent here was the State of Madras. So now understanding this, the petitioner was basically the printer, publisher and editor of this journal called as Crossroads. Now this was a Bombay-based English language weekly, and this journal used to lot of times write majorly things that were in manners that, they used to speak something against or something that was very critical with regards to then government, that was Congress. Understanding all of these things, the State of Madras at that time, Section 9, Subclause 1A of the Madras Maintenance of Public Order Act of 1949 made it illegal for this crossroad magazine or journal to enter and distribute newspapers in the former, that is State of Madras. Now the other thing here is, understanding this, our petitioner, that was Romesh Thapar, claimed that the order issued by this Maintenance Act basically contravenes the fundamental right of freedom of speech and expression that was given under Article 19(1)A of the Constitution of India. Understanding all of these things, he also argued that Article 13(1) was also void because of these things of our Constitution of India. Now, understanding all of these things, let's try to understand the judgment as well. The judgment here spoke that because of all of these things, that Supreme Court clearly mentioned that the freedom of speech and expression also includes the freedom of propagation of idea, and the freedom is ensured by the freedom of circulation. Another thing, that unless a law that is restricting the freedom of speech and expression is directly or solely against the undermining of security of the state, or it overthrows of it, then such law cannot fall within the reservation under clause 2 of the 19th article, that is reasonable restrictions. So it becomes important for us to understand these two things. Now the third thing was, there was another question that was raised, that rather than filing a writ under Article 32, the petitioner should have gone through the right way and filed it under Article 226 and first approached the High Court. But the court mentioned, that is the Supreme Court mentioned a very right thing here, mentioning that the result here, basically Part 3 elevates it to the status of the fundamental right. Now in this manner or in this matter, the petitioner has two options to seek. Now the first one is Article 226 of the High Court or Supreme Court under Article 32. It can be seen that the two therapies or both the options here are similar in nature. As a result of this, it is not required to first approach the High Court before proceeding it to the Honorable Court. So it is important for you to understand both the aspects here. Now, why am I discussing this case, or what is so important in this case? It is important for us to understand that this was the first ever judgment that was, one of the finest judgment in the history of Supreme Court of India. Now, this specifically spoke about the freedom of speech and expression and laid certain foundations of democratic organizations. Understanding all of these things, Supreme Court also mentioned certain terminologies that free political discussion is essential for the proper functioning of democratic government. So in case any journal is mentioning some critical views with regards to one of the ruling parties, that does not allow the other ruling party to ban the entry or exit of that journal or that media into their own state. Coming to the third part of the importance, it is important for you to understand this one major thing, that the first ever constitutional amendment of India that happened in 1951 was because of this case. Now, as you all can see, Article 19 was the first ever amendment that took place. So first time Article 19 was amended in 1951. So please make a note of all of these things. Likewise, there was one dissenting opinion by one of the famous judges, and that is something that I want you to type in the comment section and let me know who was this judge who gave the dissenting opinion for this case. Coming to the last part, if you have liked this video or if you find this interesting, do hit a like button, subscribe to the channel and share this with all the friends of yours who like to read and understand cases like this. Another important thing is we have already begun with the batch on the 10th of February for our CLAT 25 mission. So what are you waiting for? Visit to our nearest center and grab this opportunity. I'll see you all in the next video. Till then, bye-bye, take care and all the best.